Hello, David Nájera here again. As you know, the Canadian immigration law allows you to either prepare and submit your applications for yourself or to be represented by a third party, another person. This representative could be paid or provide his services pro bono, free. A representative can be a friend, a relative, or even a minister of your church. There's no limitation to who can represent you. The only condition imposed by the government is that you declared if your counsel is paid or unpaid, and if it is paid, to be a member of a regulatory body. So I want to talk to you today about a case that is called B in Canada. If you're interested in reading the full case, I'm going to leave the case citation in the description below. This case relates to Mr. B, who is a Chinese citizen who became a permanent resident of Canada in 2005, along with his parents and his sister. Now, 1 month later, after becoming a permanent resident, he returned to China. Upon his return to China, Mr. B remained unemployed from October 2005 to February 2007, when he entered into an agreement with a Canadian business to work as an assistant general manager in China for the following 3 years. Now, in April 2010, Mr. B made an application for a travel document, and he indicated that he has lived in Canada for only 130 days over the previous 4.5 years. So the visa officer determined that he had failed to satisfy his residency obligation, and the travel document was refused. Mr. B appealed the decision to the Immigration Appeal Division, and a hearing was held in Vancouver on April 2011. The decision made at such hearing was to reject the appeal, and Mr. B made an application for a judicial review of the decision, which is the document that we have in hand. Now, what was the applicant position? The applicant asserted that the IAD erred in two different issues, but we're going to be talking only about the second, who was that the panel did not adjourn the hearing when it became clear that his counsels were incompetent, and therefore that there was a breach of natural justice. And this is the case of a couple of good Samaritans who was Mr. B. counsels. Because he was still in China, Mr. B could not attend the hearing, but participated instead over the phone. Remember, those were the days when we didn't have this technology about having video conference every time we want, so that was the good old telephone working from China to Canada. An interpreter was required to translate for him between Cantonese and English. Now, two individuals were at the hearing to represent the applicant, to represent Mr. V. This is Ms. Leung, who was there as a volunteer from a benevolent organization, and also Mr. Lam, who was a friend of the applicant's father and who also belonged to a benevolent organization. At some point in the proceeding, which was a real chaos and a lot of delays and a lot of uncertainties and who knows what, the presiding member got tired of the extremely long list of excuses and justifications made by Mr. B. counsels. Then he invited them to stay aside and decided to proceed with the hearing under his own direction. Now, the hearing was done, and at the end, the member made the following remark. And this is regarding to our good Samaritans, right? Quote, I'm going to reserve my decision, so the decision will be provided to the parties in a few weeks. I'll just make one comment. In the future, if either or you intend to assist people, either at the Immigration Appeal Division or somewhere else, you ask that organization what the rules are and follow those rules well before a hearing date and, in fact, observe a hearing because they are usually public. So you are aware of what to do or what you can do or not do in order to better assist whoever you're attempting to assist, because you may not get as much leeway as you would in this type of circumstances. It is generally not helpful to anybody to offer assistance when you're not sure of what you're doing. And later on, he went on to say, the applicant simply chose untrained and unqualified representatives from which more could not have been expected, and he must unfortunately suffer the consequences. The application for a judicial review was dismissed, and Mr. B is probably still separated from his family. The decision on who to retain to represent you in immigration matters is in your hands. Make it count.